Growing up, I knew my parents were there for me. We celebrated family events. They were there for me when I was sick or needed help. As me and my sister grew up, we knew we could count on our parents. We were so proud to be their children. Today, we are there for our parents, to share in the celebration of their grandchildren or to be there when they are ill or need assistance. They can count on us. And now our parents look to us to take care of them. Hello, and welcome again back to Always There. I'm Michael Wilsker, and I'll be your host. I am Vice President and Care Coordinator for Always Best Care Senior Services. We provide in-home, non-medical care for seniors and their families. And our show is geared towards speaking about the issues that face the elderly and their families. Today I'm happy to have as my guest Daintria McClure, who is an elder law and estates and trust attorney with offices in Westboro and Grafton. She earned her Juris Doctorate degree from Suffolk University in Boston. She's also a certified public accountant, having earned a degree in finance from the Ohio State University. So welcome.
Thank you.
You're also a resident of Westboro, is that correct?
I am. I am.
And how long have you lived here?
We moved here, I'm going to say it was probably about 10 or 11 years ago. We're right downtown in the historic area. We were lucky enough to find a wonderful location and brought the historical home back to life and also made it an office space for myself as well.
Yeah,
Beautiful.
Yes, I live on High Street, which is also a historical area. My house is over 100 years old.
Yeah, I'm down on South Street, and the house is probably late 1700s, early 1800s. And a long line of attorneys have lived there before me when I was doing the research. It's kind of interesting.
Oh, it's interesting.
Yes.
Well, Daintria.
Daintria.
Yeah, Daintria.
Yes. It's difficult.
So you're what is called an elder law attorney.
Correct.
And how long is it? I was an attorney for over 27 years, and I didn't really know the specialty until like maybe 5 or 6 years, or 18 years into my practice. So can you explain to the audience what exactly is an elder law attorney?
An elder law attorney really helps coordinate the options for the parents as far as nursing home placement, in-home placement, caregivers coming to the home or moving the parents into a facility. As most people are aware, it's getting very, very expensive to pay for nursing homes. Right now, the average stay in Massachusetts is running about $10,000 a month. And no matter how much you really are trying to plan and save for your retirement and for all of your medical needs, it's very difficult to save that kind of money. And unfortunately, most middle-class people are not able to do so. If you are poor, then there's a program out there that helps pay for the long-term care. And if you're very wealthy, then you can privately pay. It's the middle-class, hardworking, most typical parents, where mom may have been a stay-at-home mom, dad worked, in some profession, or maybe mom was a school teacher. They just didn't have the wherewithal to pay the $10,000 a month for the nursing home. So what are their options? There's something out there called Mass Health, which really is a need-based program. And because of the complexity of it, and of course, anything to do with the government has a lot of rules and regulations, it has become very necessary to find people who actually specialize in all of the rules and regulations, because they do change quite often. So back when you were practicing, maybe it wasn't so necessary to have that kind of grasp on all the intricacies of it. But in today's environment, it's really very, very important to talk to someone, understand what the real rules are as opposed to what you might be hearing from your friends and your neighbors. So yeah, there's lots of associations out there that you can turn to. I happen to belong to a national organization called the National Academy of Elder Law Attorneys. There's a local chapter here in Massachusetts, which is very well attended and very active in legislation. There was just a bill that was passed through our group to help the person who's actually been productive enough to go out and buy their own long-term care insurance to get some protection from Mass Health coming back and taking some of their assets. So a very active group here. And you can find elder law attorneys in your area by going to the website. It's National Academy of Elder Law Attorneys, so it'd be naela.org. I believe you just type in your zip code, and you'll get a list of people within a certain radius of where you live that do, a lot of this elder law area.
How long has that association been in existence?
I don't know. They've been around since at least I'm going to say at least 15 years. I don't know how much longer before that.
Have you ever had any interaction with Attorney Margolis, who's considered the godfather of elder law attorneys?
I think that we're lucky to have a lot of really well-versed attorneys here in Massachusetts. I think that some of the other state chapters across the nation aren't as full of really knowledgeable attorneys as we have here in Massachusetts. So yes, everyone knows a lot of the people in the groups. It's a tight-knit community. There's great interaction on listservs and during meetings where all of the different attorneys that do this can share ideas, can share experiences with interactions with Mass Health to give us some direction on what their thought process is at that point in time, what direction Mass Health seems to be going in, what kind of issues Mass Health is pulling out to review more. We even have a litigation component of the Mass chapter, and that group spearheads actual litigation when we really feel that the government has overstepped the rules and regulations set forth by the federal government, because it is a federal program. It is just run by the state. So they have to adhere to the federal guidelines, and if they overstep the federal guidelines, that's when our litigation department sometimes is called into action to help structure them better, get them back on the path that they should be on.
Does the association lobby for any changes in the law or any amendments to the law?
Yes, that's what I was just alluding to when I was talking about the long-term care insurance bill that just passed. That was very instrumental. We actually have a budget. The chapter has a budget that goes towards a legislative procurer of things that we're looking for. And as a group, during some of our meetings, we'll actually discuss what direction the group wants to go in.
Is there a certification for these for
you
elder law
you
attorneys?
can get a certification that requires some very rigorous testing. It also requires other references from other elder law attorneys. It's also a in-depth analysis of some of the cases and practices that you've done in the past. So I want to say it's just the designation is just a certified elder law attorney. Some people decide that that's an important route to go, and others don't think that it's as necessary. I'm not sure how much the general public understands what the meaning of the initials are. I think in today's environment, a lot of people have a lot of initials after their names. I happen to have a lot after mine, so I'm not adding any more at this point in time. But yes, obviously, if someone has spent the effort and the energy to get their certification, then they really have a great passion for this area of law.
Now, you're also a CPA. How does that play into what you do as an elder law attorney?
Well, I think that it helps in both areas of my practice. I am an elder law attorney, and I'm also an estate planning attorney. Knowing how to read financials and understand financials is a huge part of both of those areas. I have to understand what the tax ramifications are if one of my clients is going into a nursing home and has to take out all of his 401k. I have to be able to explain that. With my tax background, it makes it a little bit easier for me to explain it. Also, on the estate tax piece of it, a tax is a tax. You know, CPAs you kind of think of as income tax, but really CPAs also handle estate tax, gift tax, and those are all pieces and components of doing a thorough estate plan. So I think it's very important to have that kind of background. It's certainly been very helpful for me. It makes it easier for me to understand what the ramifications are for my clients when I'm advising them to move their assets or try and protect some of them from some of the estate taxes that are out there.
There are attorneys that are estate and estate and trust attorneys, and are there just attorneys that are elder law attorneys, or are they usually combined into the same?
I think that there's
practice?
probably more just estate and tax attorneys. And the reason for that is that Mass Health has a lot of different kinds of rules than the estate piece of it. I didn't go into law thinking I was going to be an elder law attorney. It really kind of grew into my practice. I started life out as a tax attorney dealing with issues in front of the IRS tax court. And then I understand tax code. If you can read in a circle, you can understand taxes. So it doesn't matter if it's income tax, withholding tax, gift tax, etc. So it was an easy transition into the estate tax arena. But I found that a lot of my clients may be coming to me for an estate tax reason. But in reality, they may be one of those middle-class families that, the nursing home looming as a possible expense is really quite disheartening for some people who've tried so hard to keep something to pass on to their children. Right. It was just a natural progression to figure out ways to help them achieve both their goals, be it saving for the estate tax or saving or protecting some money for their children or themselves if nursing home seems to be on the horizon. So I don't think there's as many purely elder law attorneys. I think that, like me, they understand that you really should have a lot of different pieces in place. It shouldn't just be about getting ready for the nursing home. There's a lot of other paperwork that comes with being an estate planning attorney. Being an estate planning attorney doesn't mean you have to have millions of dollars to see me. If I had my way, I would be on a bridal registry. I'd be on the graduating seniors, high school seniors gift list. Anyone who's over 18 really should have some documents in place. And some of those documents would be a basic will. Your kids may not have anything right now when they're 18, but you never know. And it's not a difficult document to draft. But more importantly, the documents that I think are the most important are the power of attorney, which allows someone else to act on your behalf if you're unwilling or unable to do so financially. So let's just say that you were away on vacation, or typically for these kids, they're away at school, and you want to be able to converse with the college. Well, I can tell you right now that once they're 18, the college, no matter who they get that tuition check from, is not going to be talking to you. It's against their rules. But if you have a power of attorney in place, then you can talk to the school about the child's bills, about his grades, or anything else that you need to.
I didn't know that.
Yes, for most parents, it's a rude awakening when their kids are away. They're writing these big checks, and they call to see how the child is doing, and they don't get anywhere.
Interesting.
The other thing that
I better get that into effect
that
soon,
would be good.
My daughter will be going to college.
Yes. The other thing that parents are also caught aware of, and this works on both ends of the spectrum. I mean, it doesn't have to just be the 18-year-old. It can be your parent who doesn't have any paperwork in place, but isn't quite up to the energy level before, and doesn't have the wherewithal to go head-to-head with, let's just say, the bank, who may have given them a bad service charge, or there was some problem with their account, and they just don't want to deal with the bank. Well, you can't call up as a child and talk to the bank. You have to have the paperwork in place. That's what the power of attorney does. So it's very helpful on both ends. And then the other thing that's really important is the health end of this. And the health end of this would be things like a healthcare proxy. A healthcare proxy differs from a power of attorney in that power of attorney helps with your financial paperwork kind of issues. The healthcare proxy lets the person that has that power speak to the doctor, make medical decisions for you if you're not able to yourself. So given your example of your kids,
what does that mean if you can't do it yourself?
Well,
Does the
that's
person
just
have to be incompetent or?
Yes, yeah. They'll never take away your right to make your own healthcare decisions. I have a lot of very nervous husbands come to me and say, well, I'm not sure if I want my wife to be in charge of pulling the plug on me. And I say, well, they can't do that unless, first of all, two doctors agree that this is appropriate, and also that you are not able to make these decisions on your own. So that's a marital issue I try to step away from. But going back to the children that are in college, your child, something happens and he's undergoing surgery in, I don't know, Columbus at The Ohio State.
The Ohio State University,
and you need to talk to that doctor. You need to authorize whatever it is that, they were in a car accident. They're under anesthesia. They can't speak. You need to be able to talk to the hospital, the doctors, and unless you have a great relationship with that doctor, it's going to be very difficult to have that conversation. And this healthcare proxy allows you to do so.
Now, I know there's a document called the living will. Is
Yes.
is that something that has any legal relevance in Massachusetts, or?
The living will is is also known as an advance directive. You'll hear it called both things. Lots of states around the United States actually have enacted a law that says these living wills or advance directives are legally binding documents. Massachusetts hasn't gotten there yet. I still encourage all of my clients to go ahead and fill one out. What this is a dying with dignity piece, I guess, is the easiest way to explain it. If you're dying of cancer and you're not really able to communicate because you're just not quite as healthy as you were, it gives your healthcare proxy the ability to talk to the doctors and say, well, let's go ahead and increase the morphine to make my mother or father, husband, spouse, whomever, more comfortable. Even though it may be shortening their life because morphine will kill you. It's better to, perhaps in this instance, to go ahead and let them have the extra dosage, even if it's shortening their life. Some other decisions that may come up is a feeding tube, or even a do not resuscitate order, where you don't want to make heroic measures. I'm not talking about standard procedures that are pretty common to have happen when someone's getting sick. These are usually ongoing illnesses where the person is no longer able to really articulate what it is they want done. They may have said something to you in the past, like, I don't ever want to be on a feeding tube, don't hook me up to machines.
Right.
Even though it's not a legally recognized document in Massachusetts yet, what it does is several things. First of all, if you ever have to go to court to fight someone who's pushing against this, it's one more piece of evidence that says this is really what he wanted. The other thing that the people don't think about, it is a very, very difficult place to be, to have to make those kind of decisions for someone else. This paperwork makes it easier for your kids or whomever it is that you put in that role to make those decisions without all that guilt, without all that, and by doing the right thing, the second guessing. If you've had these conversations with your children and you have this advance directive / living will, then at least you know that your kids aren't going to be eaten up by guilt if they do end up stopping some course of treatment or increasing your morphine that shortens your life. The other thing that, going along with the medical theme here, is a HIPAA release. Everyone, again, should have this. You can't be a healthcare proxy if you can't get the information to know that you need to be a healthcare proxy. The government has put into place protection for your medical records, and that's really where this is coming from. It was never supposed to be that no one could call the doctor and find out how you were doing on a pretty basic level, or even to find out what room you're in at the hospital. I mean, even that's becoming very difficult. Has someone been admitted? There's a lot of walls that are going up now to protect the privacy. I think it's overreaching. But that being said, at least if you have a HIPAA release, you have the authority to go to the doctor, to go to the hospital, to go to the medical office and say, please release the records, and or please talk to me so I can help my mother make some decisions. You can enact a HIPAA release without having to be unable to make your own medical decisions too. It's unlike the healthcare proxy where you really can't make your own decisions for that to be effective. The HIPAA release goes into effect immediately.
I know from my years of practicing law that in order for you to do anything under a will, it has to be the original. How does that work with a power of attorney, the healthcare proxy, and the living will? Can you present copies of those to the hospital, or do they have to be originals?
Well, it depends on the hospital's policy. It depends on how lawyered up the hospital or the doctors are. Most of the documents actually say in them a facsimile or a copy of this document is in full force and effect. All of my documents say that. That being said, real world, it may be that someone balks at the idea of not having an original in their hand. What I usually suggest to my clients to do is the next time they go to their doctor, after they've seen someone like myself and have these documents, take it to the receptionist and have her take your original, go make a copy, and put it in your file. If there's a certain hospital that you go to all the time, or you think that that might be the one that you end up at, go to the administrator and show them the original. Let them make their own copy. Some places have a true attested copy stamp that they can put right on the form, and that way it's a non-issue.
Well, I know the healthcare proxy and the power of attorney have to be notarized, correct?
I do this all the time, and I automatically just do it. I don't know off the top of my head which of the ones. Power attorneys really should be anyway.
Yeah.
I'm not sure if they're required or not, but the reason for that is sometimes you might actually have to record a power of attorney,
Right.
And the reason that you might have to record it is there may be a transaction that involves real estate, and they do need things in a certain way at the Registry of Deeds. So better safe than sorry. Most attorneys are notaries too. So I think I notarize all my stuff. I think I have 2 witnesses and notaries on everything, just because it's not any more difficult to do it that way.
What about a living will? Does that need to be notarized also?
I notarize and witness those. Yep. Yep.
And just going back to the powers of attorney, I know there's a durable power of attorney, and there's another form called a limited power of attorney. Can you explain the difference?
Well, limited power, there's actually 3 different kinds.
Okay.
There's a limited power of attorney, which you in your practice may have seen before, and that is a power of attorney that's limited to a specific act. You'll see this a lot. Let's say you're buying a piece of real estate and you're going on vacation and you don't want to be at the closing. Your real estate attorney will fill out a limited power of attorney that gives them the ability to go to that closing for you, sign the documents you need, and then that limited power of attorney goes away when that task is accomplished. I think what you might be also thinking about is there's durable and springing powers of attorney. What I mean by that is a durable power of attorney lasts, it's effective immediately, and it lasts even if you become incapacitated. Springing powers of attorney are a little bit different. They don't come into place, they don't become active until you spring into the incapacity type of role. I don't usually, I can probably count on one hand the number of non-durable power attorneys I've ever, or springing power attorneys I've ever done. And everyone says, well, I don't want them to have the ability to go down to my bank account right now and clean me out. And my answer to that really is, well, if you don't trust them now when you're fully conscious, then why are you naming them in this position when you're not going to really be able to do anything to stop them? So you really, a lot of people aren't sure who to name as their power of attorney because it's a big job, or it could be a big job depending on how intricate your life is. It doesn't have to be your relative. It doesn't have to be your firstborn. I hear that all the time. It has to be Johnny because he's the first male, or it has to be Susie because she's the firstborn. Find the one that's the most reliable, the most detail-oriented, the most organized. It might be your youngest. It might be your cousin. It might be your aunt. I don't know who that person is, but they don't have to be related to you. They don't have to be one of your children. It doesn't even have to be your spouse, although usually in most marriages I do see the spouses being each other's with backup as kids.
Do you find yourself being a mediator when you have the family that one of the children is appointed or someone outside the family is appointed? I know when we did our will, my first wife and I, we named as guardians friends of the family, friends of ours, very good friends of ours. We didn't want anybody within the family to be the guardians, and my in-laws at the time were just furious over that.
But
so you get situations like that?
I'm very happy to hear that you actually told your in-laws, though. See, this is really where the bigger problems come in, is people sometimes think that these are their private documents and they should be held close to the vest and not disclose what their plans are until it comes into effect. And I totally disagree with that. I think communication is the key. It gave your in-laws a chance to vent their feelings and frustrations with you, and then maybe, possibly change your mind. And even if it didn't change your mind, at least they felt better to understand why it is you were making the choices you did. So there's going to be less litigation down the road because they really heard it from you as opposed to a document or the friends that you had nominated. So I think that's huge, and it was a very smart idea for you to talk to.
Can there be litigation over that?
Oh, absolutely.
If the husband and wife are competent when they make the decision in front of an attorney?
Well, there won't be any litigation until it comes into play.
Right.
And then what will happen is that the in-laws, the grandparents, will go to court and they'll ask for custody of the children. And they're going to have to show why they're better at it. I mean, just much like in a divorce or anything else. I mean, the courts can always come into play if they're willing to pay enough for an attorney to do it. You know, hopefully they won't win, but who really wants to go through that hassle? Your kids are going through enough. If they've lost both of you, they've gone through enough. They really shouldn't be in an arena where their caregivers and their grandparents are fighting. And that's why I think it's so hugely important to make sure that everybody knows what your decision is and everybody knows why you've made that decision, if it is an unusual one.
Well, you seem to really know a lot about what you do.
I enjoy what I do.
Very impressed. I'm sure the people watching are very impressed. Just before we finish up, how do you get referrals? How do clients come to you?
A lot of my referrals come from my clients. Years ago, I was actually starting my own practice, a little nervous about hanging out my shingle. I think that was probably 12 years ago. I went out on my own, and I had a small group of tax clients that I'd had forever, and I kind of put them all out to work. I said, Daintria is starting her own business. Go forth and find me wonderful people like yourselves. And those clients have been wonderful to me. They've referred clients to me, and those new clients have then referred other clients. That's my best referral source because they already know a little bit about me when they come in. My other great referral source is other attorneys. As I said before, a lot of attorneys in today's environment are highly specialized, much like doctors. A lot of my colleagues might be patent attorneys, or they might be real estate attorneys, or they might be biotech attorneys. They're not estate planning attorneys. They're not mass health attorneys, elder law attorneys. So they'll send their clients to me as well. And then, of course, accountants are also a great referral source for me.
Well, Daintria, thank you so much. You really, again, very impressed. I've known you for a number of years and still amazed at the amount of information that comes out of you.
Comes out of my mouth. I just don't ever be quiet too.
No, you're great. You're great. And I highly recommend you to anyone that's watching today.
Well, thank you.
So we're going to wrap up. Thank you for joining us, and we'll see you next time on Always There.